Let's get started. So my name is Nick Bedenk. I'm an attorney at Legal Aid Chicago. I work in the employment team. We handle unemployment benefits as well as other employment-related claims like discrimination claims and wage and hour claims. This is being recorded for distribution with some of our partner agencies. So if you are one of those individuals and you have a question about anything in the presentation, feel free to reach out to me at 312-229-6394. You can also reach out to me via email at nbedenk, that's NBEDENK at legalaidchicago.org. I'll have some contact information up at the end of the presentation as well. Okay, so unemployment benefits and how they've been affected by COVID-19 is what we're going to be addressing today. We're going to discuss eligibility, some of the federal enhancements that have been put in place, as well as considerations for non-U.S. citizens and whether or not they will be eligible for unemployment benefits. Starting first with what are unemployment benefits. Unemployment benefits are intended to provide economic relief to individuals who've become separated from their employment due to no fault of their own. So if you qualify for unemployment benefits in the state of Illinois, you can earn up to half of your weekly earnings for a maximum of 26 weeks in a one-year period. The federal legislation, the CARES Act that was passed into law, provides an additional 13 weeks, resulting in Illinois of 39 weeks of eligibility for unemployment benefits. One of the most important things for maintaining eligibility for benefits is demonstrating that you are able, available, and actively seeking work while you are unemployed. So able is your ability to perform tasks. You have to be able to complete a job. Available is looking at how much time you have allotted on your schedule for work. So if you are making your schedule so restrictive that you're not able to work or actually able to get a position, you're not going to be considered available for the job. In any case, in order to demonstrate your ability and availability, you need to register at Illinois JobLink at illinoisjoblink.com, where you will be providing information on your job search to IDES. The exception to this rule comes in the federal legislation, where individuals who have been temporarily laid off due to COVID-19 do not need to register at Illinois JobLink. They need to be willing to return to their position as soon as that job is able to open up. So again, that is only for temporary layoffs. If you have been diagnosed with COVID-19 or other circumstances that we'll get into later, you will still need to register. But if you're temporarily laid off, you do not need to register and search for new jobs. I'm just getting a little bit of feedback, so if you could just mute your mic if it's not already muted, I'd appreciate that. Beginning to look at eligibility. So if you've been terminated, separated, discharged, laid off, furloughed, RIF, fired, or let go, you will be eligible for benefits unless you were terminated for what's defined as disqualifying misconduct. Disqualifying misconduct is the intentional willful violation of a reasonable company rule or policy that either harms the employer or has the potential to harm the employer. So a violation of a common sense rule that the employee should have known about is normally not going to be enough to disqualify an individual for benefits. The first issue is that you actually need to have a rule in place that the individual knows about and then violates it for them to be disqualified. Usually what you're looking for is the person has been warned repeatedly about, or even warned just once, but they have been put on notice that their conduct is violating a company policy, and then they continue to do that. There's going to be some exceptions for particularly egregious behavior that really deviates from the norm of what's acceptable, but in most cases, this scenario is not going to make an individual ineligible for benefits. Poor performance. Again, this is an instance where there is not going to be a disqualification. Not being good at your job is not misconduct. It is not something that you are willfully doing. It's just you're not able to meet the employer's expectations. So poor performance is going to result in eligibility for unemployment benefits. Again, disqualifying misconduct is the deliberate and willful violation of a reasonable company policy. In order for a company policy to be reasonable, it has to provide guidelines that the employee can follow to know whether or not they're in violation of the rule. So an example would be a company that has a permissive internet policy. The policy states that individuals are allowed to use the internet at work for limited personal use. So limited personal usage of the internet is allowed. A woman who works at the company uses the internet every day on her lunch break. It's an unpaid lunch break, and she uses it for personal reasons for a half an hour to an hour of that lunch break. The company finds out about this. For some reason, they're not happy about it, and they terminate her. She applies for benefits. The company protests, and they say she violated the policy. We said limited personal usage is okay. What she did was way beyond limited. This woman would be entitled to benefits because mainly there's no further definition of what limited personal usage is. It didn't say beyond 20 minutes is excessive. So because it just says limited personal usage is allowed, without further guidelines, that would not be considered a reasonable policy. Additionally, it's not likely that the employer would be able to show harm or potential for harm, since the use of the internet was during the unpaid lunch break, but really the focus of that example is on the reasonableness of the policy. On this slide are some examples of disqualifying misconduct that do not require showing that the individual was on notice, where you fail to maintain a license or a certificate, if you damage employer property through grossly negligent conduct, consuming alcohol or illegal drugs are some examples of disqualifying misconduct. So if you were not terminated or laid off or furloughed, you most likely voluntarily quit your job. In most instances, individuals who voluntarily quit their job are not going to be eligible for benefits. The exception to that is when you are able to demonstrate that the reason that you left was due to good cause that's attributable to the employer. So the employer took some action that forced you to leave the job. Some examples of this are employers violating state or federal laws by allowing sexual harassment or unlawful discrimination to persist in their workplace, changes in terms or conditions of a job causing the employee to quit. So for example, you're working as a chef and your duties are to prepare food, and the next day you come into work and the owner of the restaurant says, from now on, you're going to be a busboy. You're going to be, bussing tables, picking up plates. It's completely different than what you were hired to do. If an employer does something like that, then you are likely going to be eligible for benefits. These last two, abusive behavior by coworkers or supervisors or unsafe work conditions, are going to be sufficient to show good cause. However, you do need to demonstrate that you communicated and that the employer was aware of the abusive behavior or unsafe work conditions. So it's not just enough to say, hey, there was not this medical item provided today or this protective gear provided today, so I'm quitting. You have to give the employer a chance to correct the problem. There's a certain set of situations where the law provides for leaving without good cause attributable to the employer. For anyone interested, it's under Section 601 of the Act. The Act is 820 ILCS 405, Sections 100 going forward. So those examples are the health condition of an employee or spouse, domestic violence, needing to move to accompany a spouse who's in the military, or leaving to move with a spouse who's accepted a new job. If you're moving across town, that's not likely to be enough. It's more where you have to move a far enough of a distance where it's no longer practical for you to keep the job that you are at. Looking specifically at separation from work due to COVID-19, you will be eligible for benefits if you have been confined to your home due to a COVID-19 diagnosis, if you need to leave work to care for a spouse, parent, or child who's been diagnosed with COVID-19, if you've had to leave work due to a child's school closure, or if you've been temporarily laid off due to COVID-19. In the first three circumstances, you will need to show that you're able and available for work. The caveat to that is that it's work that you could do from your home. So mostly like data entry jobs that allow for telework. The state is supposed to be flexible with this, understanding the current environment and the small number of jobs that may be available that fit what you can do from home, but you still are required to at least put in a good faith search for those types of jobs. Now, you will not be eligible if you left work voluntarily due to a concern about COVID-19, just a general concern that someone may come into your work who's infected, so you don't want to be at work is not going to be enough. The situation would be different if the employer is not providing protective equipment, is not following the guidelines set out by the government perhaps, and you inform them that corrections need to be made and then those corrections still aren't made. That could be a case where you are eligible for benefits, but just a general concern is not going to result in eligibility. Also, if you're receiving paid leave, in most circumstances, that is going to disqualify you for benefits. It certainly will disqualify you for receiving any federal benefits. How are benefits calculated in Illinois? In order to be eligible in Illinois, you need to have earned at least $1,600 during your base period. Your base period is determined by looking at the earliest 4 of your last 5 calendar quarters preceding your claims filing. So what does that mean? Calendar quarter, separate the calendar into 4 sections of 3 months each. We are in April right now. If I become unemployed today and go to file for benefits, my last 5 calendar quarters would be the first quarter of 2020, January through March, as well as all 4 quarters of 2019. So that is 5 quarters. So what are the 4 earliest quarters? The latest quarter would be the first quarter of 2020. So I would disregard that. And my 4 earliest quarters would be each quarter that existed in the year 2019. Okay, so I would look at those 4 quarters and ask first, do I have $1,600 that was earned in this base period? If the answer to this is yes, you will move to the second question, where you disregard your highest paid quarter of the 4 quarters you are considering, and then ask, is there still $440 that was earned across these 3 remaining quarters in my base period? If the answer is yes, then you will be eligible for benefits. Part-time workers will be eligible as long as they meet the income requirements as well. If your hours have been reduced at work, that's generally not going to make you eligible unless your benefits, unless your wages have been reduced to the point that you are earning less than half of what you would have earned under an unemployment benefit. Okay. There any questions so far? I'm not able to see the chat.
Nick, I have a question. Is the money in the base amount, does that have to be all from the same job?
No. It just has to be during your base period.
Thank you.
And Nick, this is Rich. And you have to have, just kind of repeating, I think what you said is at least one of those quarters you have to have 1,600, and then the other ones you have to have 440, right?
It's slightly different. So you need $1,600 earned in total across all 4 quarters. Then after that, the next step is to disregard the highest earning of those 4 quarters, take the 3 remaining quarters, and ask in total in the 3 remaining quarters was $440 earned at all, not in each quarter, but just across the 3 remaining quarters was $440 earned.
So just to be clear, you have to make roughly $150 for the 3 other quarters, not 440. Okay. Roughly 150, I think.
Well, you just need, if you have 440 in 1 quarter or 440 spread across the 3 quarters, you just need 440 to have been earned. Okay, so now we'll move on to look specifically at the federal enhancements that have been provided through the CARES Act. So the first section of the CARES Act is the $600 additional benefit that will be applied to accounts through July 31st of 2020. There is not a separate application that's needed to receive this benefit. For all federal benefits, they are received by applying through the state agency. There's not a separate application process. The extra $600 benefit will not count as income for purposes of Medicaid or CHIP program calculations. And then going back to the calculation that I had on the last page, there are other financials that can affect how much you will earn in your weekly benefit. That was just general guidelines for calculating a benefit. So whether your earnings are more through unemployment benefits than they had been when you were earning wages, regardless if you were working part-time or full-time, as long as you qualify for $1 of unemployment benefits, you will qualify for the $600 weekly benefit through July 31st, 2020. The other big component, there's 3 big components of the CARES Act. The one we discussed briefly earlier, which extends the state unemployment benefits by 13 weeks. The second section is the additional $600 a week benefit. The third is titled Pandemic Unemployment Assistance, and this is the section that provides benefits for people who do not qualify under state benefit programs or who have exhausted their benefits under the state program. So if you are an independent contractor, gig worker, and another worker who doesn't otherwise qualify for benefits, you should be able to apply through states to get those benefits. IDES released an update that they hope to be accepting applications and getting money dispersed beginning in May. By May 12th is what they're hoping to do. So it's not up and running yet. Hopefully they'll be able to meet that target and get people who are really struggling right now some much needed funds. So what you're eligible for is up to 29 weeks of benefits through December 31st, 2020, which can be applied retroactively. The minimum benefit that you are entitled to is at least 1/2 of the state's average weekly benefit. So what we're looking at here is individuals across the state, how much they earn on average, and you are entitled to at least 1/2 of that. That's the minimum bar that's set. If you qualify for the federal pandemic unemployment assistance, you also qualify for that $600 weekly benefit. Some circumstances that make you eligible is if you are unable and unavailable due to a COVID-19 diagnosis of your own, a household member, or someone you care for. If the place of employment, your place of employment has closed because of COVID-19, or you're scheduled to start new employment but cannot due to COVID-19. These are all circumstances that you would not be qualified possibly under state benefits, but you would qualify for federal benefits that you would apply for through your state program. Now that we've discussed the federal enhancements, want to look at some considerations for non-U.S. citizens. In order for any non-U.S. citizen to qualify for benefits, you need to meet all other requirements, and additionally, you need to have had valid work authorization at the time the wages were earned, as well as the time benefits are being sought. There is definitely some gray area in this area of the law. The two groups that we can confidently say are eligible are lawful permanent residents or green card holders who have work authorization, as well as a group of people who've been identified as permanently residing under color of law or PRUCAL. PRUCAL certainly includes refugees, non-U.S. citizens with grants of asylum, and non-U.S. citizens who've been paroled into the U.S. under 8 U.S.C. 1182 D5. PRUCAL should include these other statuses. There is an argument to be made, so we are certainly not discouraging anyone from applying. And if anyone with any of these statuses does apply and is denied, encourage you to reach out to us so we can consider whether there's an argument to be made for us to represent you. So these groups that should qualify are DACA recipients and others with deferred action, VAWA applicants and VAWA self-petitioners, U-Visa applicants and recipients, adjustment of status applicants, T-Visa recipients, again, all who had work authorization at the time they were performing the job, as well as at the time that they're applying for benefits. Just going back, so some workers that I don't want to say definitely don't apply, but that there's going to be a much harder argument to say that these individuals should be entitled to benefits are going to be anyone with an H-2 visa or an H visa. So if you have those and apply and are denied benefits, still feel free to reach out to Legal Aid Chicago for possible representation. But unfortunately, the way the laws are written, I don't think that in most instances those individuals will end up being eligible for benefits. But there's not a legal detriment to applying for benefits. So anytime you think you may be eligible, there's no reason why I would tell anyone to not apply. The process for unemployment. The first step right now is to apply for benefits online. That's the only way that the IDES office is accepting applications. They also have further restrictions about you are only able to apply based on the first letter of your last name on certain days, and they have cutoff times each day. I know that they are working right now to increase capacity. They're trying to hire 200 more employees to help ease the burden that has been created by COVID-19 because they're overwhelmed with applications. So we will see how that rolls out. I know people have been having a lot of trouble contacting anyone on the phone. The best advice that we can give right now, unfortunately, is to just apply online and to keep trying, which isn't very helpful, but they are just overwhelmed and we haven't received any better direction. So after you apply for benefits, the local office will make a determination about whether you are entitled to benefits or not. That is sent out, and either the individual or the employer may protest the receipt or the denial of benefits. Once this is appealed, it is appealed to an administrative law judge or an ALJ. That appeal must be made within 30 days of the denial of benefits. At the ALJ stage is where an attorney can get involved, and it's really the most important phase of the process because this is where a record is established, and it's the record that'll be reviewed going forward if the appeals process continued. So on the phone hearing, the employer and the employee are both allowed to present evidence, to question witnesses, to give opening and closing statements. Once that is done, the ALJ will make a decision, send it out in the mail. Any decision that you would like to appeal, you must again do so within 30 days from the denial of benefits, and you would do that by appealing to the Board of Review. At the Board of Review, there's no oral argument. The Board of Review is going to review the record from the ALJ hearing, and they don't typically take new evidence. The appeals are submitted in writing, and the Board of Review has 120 days to make its decision. It's important that if you are interested in representation and you receive an ALJ denial letter, that when you appeal to the Board of Review, you also request a copy of your transcript. It's important for attorneys to be able to review the transcript to know if there's a way for us to be able to step in and assist you at the Board of Review level. So when you're appealing from the ALJ to the Board of Review, please request your transcript from the ALJ as well. So once the Board of Review issues a decision, the next step would be to appeal to Circuit Court under the Administrative Review Act. You would have to do this within 35 days of the denial of benefits from the Board of Review. At this stage, there is a closed record and no new evidence is taken. On questions of fact, the court is going to be very deferential to the agency decision, and on issues of law, they're going to be less deferential. The process here is normally that a written argument is submitted to the judge, and then it's followed up with oral arguments. It can take a couple months to get a decision at this stage. If there is not a favorable decision, it's a possibility that you can appeal to the appeals court and to ultimately the Supreme Court. However, this does not happen often, and typically the end of the road happens at the circuit court stage, but it doesn't have to. That's just typically, in most cases, where it does end. What we're advising workers now is to file online and unfortunately just bear with IDEs as much as possible because they're just overwhelmed. Another option would be to call us at 312-341-1070 for any denials of benefits if you are interested in representation. If you have questions or want information, we're encouraging people to reach out to our 1-800 number, which is listed here, 800-445-9025. Again, there's no legal consequences for filing for unemployment benefits. So if you think you're entitled or that you may be entitled, there's no reason I would discourage you from applying for benefits. And this is the contact information for everyone on the employment law team. Again, my name's Nick Bedenk, and I can be reached at nbedenk@legalaidchicago.org if you have any questions about this presentation. Does anyone who's on the chat right now have any questions?
Yeah, I have one.
Sure.
Can you hear me?
Yep.
Okay. The question is, if someone typically works out of their home, like they have a business out of their home, let's say they're a hairdresser, and they now don't have anyone coming into their home so that they can cut their hair because of COVID-19, do you think that they would be eligible for benefits?
So let's take a look at what the federal employment, because really the backstop here is going to be if you don't qualify for state benefits, you might qualify for federal. So if you're a hairdresser, the first question I guess would be, are you paying into the unemployment insurance program? How are you classified as a worker? I would need to know answers to those questions before giving specific advice. But if this individual were to be considered an independent contractor, the PUA would likely be their best bet for eligibility for benefits.
Okay, thank you.
Anyone else? Okay, great. Well, if anyone does have any questions, feel free to reach out to me. Thanks for joining the call, and hope you guys have a great rest of your week.
Okay, thanks.
Thank you.